The screen boxes NOPQRST. Those who did not opted it, whether they are present now. Okay, I think they are not present now. Okay, let me continue my class. In my yesterday class, I was dealing the literary rule. Yes, mute. Everybody can mute. When you want to speak at the time, you can unmute and speak. But the time being, you mute everybody. Mute all. So, I am dealing the grammar rule or linear rule or literary rule. These are the different names are given for that one. So, the interpretation importance necessary also that I made it very much clear in my last class. But here also I enumerated. In number 1, there is no universal way of drafting the statutes. Number 2, there are sometimes hidden intention of the lawmakers which cannot easily be seen by just reading the provision of the statute. 3, interpretation of the statute may sometimes be difficult whenever words used have more than one meaning or they are ambiguous. And 4, statutes are always open to all manner of argument and interpretation. And the 5th, the drafting errors, and like the 6th and 7th goes new development, there is a technological development and changes in the use of the language. Because of these factors, statutory interpretation is mandatory, must. And we discussed the case law also, literary rule, the London and Northeastern Railway Company versus Berryman. In this case law, Mr. Berryman was a railway worker. He's an employee and who was hit and killed by a train while he was doing maintenance work between the rails. Participants, are you hearing me? And as well as could see my screen also. Anyone can unmute and say yes.
Yes.
Very good.
Yes.
Very good. I appreciate. Now mute. So regulations stated that a lookout should be provided for man working on the other railway line for the purpose of repairing it. And here the Berryman was maintaining the line. His widow tried to claim the compensation for his death because the railway company had not provided a lookout man. Whenever the work in progress in the railways, always there is a man at both the sides and with a red banner fixed to both the rails. Have you observed any time? Anyone can give me the answer? I said anyone can unmute and give me the answer. If you did not understand the question, say pass on.
Pass on.
I asked the question, whenever the railway track maintenance is going on, one of the railway employee at both the sides, upside and downside, and the middle, the people are working, and he will be standing there with a red banner fixing to the rails. Did you see such a scenery? Did you see such a situation?
Yes, we have seen such situation.
What is the purpose of the man standing at both the sides?
To alert the passerby.
He is standing to alert the people, those who are working, if the train is coming, at that instance he will alert it. Moreover, they will fix the speed also when the maintenance work is going on. A signboard is fixed, speed limit 10 kmph or 20 kmph. With that speed, he should have to pass on the repairing line. That is the indication. But when he was greasing it, maintaining the rails, at that instance, there is no man watching at their place in the respective places, and he was hit by the railway engine. The widow filed a case law. So actually, the employees who is maintaining the work, and is the maintenance in the sense they are laying the sleepers and packing the sleepers. I don't know whether you know it, what is meant by sleepers. Do you know it, what is meant by sleepers? Give me the answer.
Asa. Asa.
Where the railways line rails will rest. Did you see the now which is kept on the screen? Did you see it now?
Yes,
Where
we
the
see.
rails will rest. Rails will rest on the sleepers. Earlier the sleepers are imbao, wooden, but later on they are iron. But nowadays, nowadays, give me the answer. Either you know it or you don't know it. If you know it, you tell me. If you don't know it, say, I don't know, sir.
I don't know, sir.
Yes? Say again.
We don't know, sir.
Why you are taking so much time to say, I don't know, sir? Could you not see here? My cursor is here. Did you see it? My cursor is moving. Did you see it? What are they?
We see it, but we
Yes.
don't know it.
Is it made of chuma? Is it made of imbao? Is it made of concrete?
They are made up of concrete.
It is made of concrete now. Because imbao is a now Ghalisana, chuma is a Ghalisana, concrete is a cheap. So they are laying the sleepers for them. They say a person who is laying the sleepers and packing the sleepers, they will be entitled to get the compensation if they hit by a railway engine. But this fellow is, when changing the line, there would be a grease applied over there from one line to another line. Did you observe it at any time? The two lines are there. When they change the line from one line to another line, and they will apply the grease over there. At that instance, this fellow is greasing. He will not come under the definition of the employee in the particular area, and he cannot be entitled to get any compensation. That is the literary meaning is taken into consideration in that case law. Is it clear? So the widow is not going to get any compensation here. The court looked at the specific words in the regulation and was not prepared to look at any broad principle. The purpose of making a regulation that a lookout man should be provided was to protect those working on the railway line. Who is the lookout man? A lookout man is such a person and who is be standing at both the sides of the railways where the maintenance work is going on. Is it clear?
Yes, it's clear.
How many types of the railway tracks are there? If you know it, you tell me. If you don't know it, you say pass on. Anyone? In Monza, at least tell me in Monza, what type of the railway track it is. I will give the example. Number 1, broad gauge. Number 2, meter gauge. Number 3, narrow gauge. Sio kimya. I gave the three options. Choose one. Say loudly. Oh, sir. It is not a narrow gauge. It is a meter gauge. Exactly 1 meter is there. Okay, mute. After giving the answer, you mute. So in the valleys, there is a narrow gauge. I don't know whether Tazara, Zambia, which type of the gauge it is. From Dar es Salaam to Zambia. Please tell me, I don't know, or you know it, or you don't know it. That's the purpose of asking you. Okay, forget about it. So here they are not going to get it. So rules of statutory interpretation, we have a literary rule or plain meaning rule or a grammar rule, all the same, only one. The interpretation of the statutes by strict or liberal, both the ways. In course of the interpreting the statutes, court have developed the guiding approaches or rules which are grouped into the two. Number one, main principles or primary rules to the statutory interpretation and subsidiary or secondary rules to the statutory interpretation. Yes, that's true. Yeah, there one is the primary legislation and there is secondary legislation. The primary rules of the statutory interpretation include the literal plain meaning rule, the golden rule or Mitchell rule, the Hayden's rule, and the purposive or technological approach rule, and what we discussed in the beginning. And here, when you are discussing the plain rule is concerned, they will, when the words are very much plain, when there is no ambiguity, at that instant the plain rule could be used even though the absurd results may occur. The reason is a judge may not add or extend the meaning willfully or fancifully give a different meaning when the meaning is very much clear over there. So another case law we discussed, of course this is the Dupont Steel versus Sayers case law. And he also says when the meaning is very much clear, at that instance you are not supposed to deviate it. But in my last class, yesterday class, what I discussed over there, cutting the nose, cutting and wounding by the instrument. But this fellow has bitten the nose. So bitten will not come because it's bitten with the teeth. A teeth is not the instrument. The plain meaning rule is given. But it is not a proper way. Even biting either by the teeth or by the instrument or by any other means causing the harm, it amounts to the injury. Hence, it will be extended. Either the instrument can be used or teeth can be used. Am I right?
Yes.
Even a martial art man with the only hands, he may kill a man also. But he did not use any instrument. He used only hands or the legs. Can you say that he is not stabbed, he is not wounded, but the man is died? Can you take the interpretation of the literary meaning? Answer is no. Answer is
No.
yes, I appreciate. The plain meaning rule emphasizes that it is not for the court to decide whether changes would be made to the law. Court have to adapt the grammatical or ordinary meaning or plain meaning or linear meaning or literary meaning words they appear in the statute. Under this rule, the judge considers what the statute actually says rather than what it might mean. So it is expected by the citizen that law will be applied by the courts as they appear. Hence, legislative text is presumed to be the coherent and consistent and thus preferable compared to any other external influence. So, application of the plain meaning rule, we will see one of the local case law. And this case law you have studied in the legal methods. What is the name of the case law?
Singida RTC versus Tanzania Telecommunication Corporation.
What is RTC? What is the full form of RTC?
Regional Transport Commission.
Yes?
Regional Transport Commission.
Regional
Road
Trading
Transport
Corporation.
Corporation. Singida Road Transport Corporation versus Tanzania Telecommunication Corporation. Before the internet is concerned, phone is concerned, if any emergency message would be passed through the postal department, what type of the instrument they used to be? Anyone? Did you understand my question first?
No.
Sending through post office.
Unless until I say to you and you saying no, you should say, sir, can you repeat the question? You should say. Okay, I repeat the question. Before the invention of the internet and emails, if a person wants to send the emergency message through the postal department, how the postal department will send it at the time? That is my question. If you don't know, say, I don't know. Or you say, pass on.
Telegram.
Yes?
Telegram.
Telegrams. Do you know how to operate the telegram? Did you see the instrument? Did you see the instrument?
Oh, we did not see the instrument, but
Yes,
it was
yes.
Telegram.
I can show you, but it takes a lot of time for it. They make a tuk 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 tak, tuk 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 tak. There is the sounds are there. With that, they know what A stands for, B stands for, so and so. They used to send the message by telegram, and the other person used to decode it in a written form, and they will deliver it to it immediately to the parent. Just within hours, it will go. Generally, the people used to send the death news with the telegram. So now let us see that what the Singida post office did it here. Owned by the defendant to Galco and Dar es Salaam. The said telegram, here I already put it over there. Even by looking at the my screen, you can able to give the answer. The said telegram required the said, what they said, Galco and at Dar es Salaam to dispatch or supply 4,000 corrugated iron sheets to the plaintiff. How many did not know what is meant by the corrugated iron sheets? Keep your hand on your moyo and tell me. Did you know what is meant by corrugated iron sheets? Answer.
Mabati.
Bati, correct. Corrugated. What is meant by corrugated? I know it is a body. I say corrugated iron sheet means it is like a burros. Like a burros. Burros means here I have shown you. Up, down, up, down, up, down. Like that it will come. So that is, see here I have shown you. Did you see it now? Corrugated. Did you see it now?
Yes, we see.
Yes.
These are called corrugated. See, corrugated. Down, up. These are called corrugated iron sheet. How many they said? 4,000 it is made. 4,000 corrugated iron sheets to the plaintiff. Owing to the negligence of the defendant servant, means postal department, either at the Singida post office or at the post office of Dar es Salaam. 4,000 read as 40,000. Actually, he said 4,000. But at the time of either in the mistake in the Dar es Salaam or the mistake at the Singira, they typed it 40,000. So 40,000 corrugated sheets were sent by the Galco, dispatched to the first consignment is 12,000. Actually, they need how many thousand? How many thousand? Actually, they need how many thousand? Give me the answer. Actually, they need how many thousand? Amna kimia. Say, I don't know.
Pass on, Professor.
Yes? 4,000 actually. They said 4,000, but the mistake of the postal department, they made 40,000. So in the first consignment, they have sent how many? 12,000. On the receipt of the wrongly worded telegram, what they say, the first consignment is 12,000 corrugated iron sheets to the plaintiff. Actually, the plaintiff need only 4,000 corrugated iron sheets. In turn, the plaintiff was forced to transport back to the Galco the excess amount of the corrugated iron sheets at the cost of the 39,200 Tanzania shillings, which amount they were claiming from the defendants. So, actually the plaintiff need only the 4,000, but in the first consignment, he supplied the 12,000 and he took the 4,000 remaining balance and he sent back to the Dar es Salaam on his own cost, and he claimed the cost. Who claimed? Plaintiff claimed the cost from the defendant. So Section 73 Class B and Section 117 of the Postal Department Act provided that the defendant corporation shall not incur any liability by the reason inter alia of any delay in the transmission or any telegram or any person or any reason or any error in omission or any omission from or non-delivery or misdelivery of any telegram. A blanket clause is there. Whenever a person orders a particular thing, the other defendant should have to confirm whether he needs the 40,000 corrugated sheets or not. Because disclaimer clause is there at the postal department, and hence postal department is not held liable for their mistake. The counsel for the plaintiff contended that statutory provision was not intended to cover all types of the errors. In solving the issues, court had this to say: the cardinal canon of the construction of this statute is to give the words used in the statutes their ordinary plain meaning. Generally speaking, therefore, the courts must be content to accept the ordinary and plain meaning of the words used in a statute as a conclusive evidence of what legislature has said and meant. When the postal department made the disclaimer clause over there, at that instance, postal department is not held liable even though postal department error was there. The court emphasized that the principle of interpretation can only be departed from where the statute is vague or ambiguous. Where the statute is vague or ambiguous, at that instance only the court will interfere it. Otherwise, the court will not interfere it. They take the plain meaning. But mistake was done by the postal department either in the Singida or in the Dar es Salaam. Instead of 4,000 corrugated, it is typed as a 40,000. So therefore, court held that in the absence of the evidence to the effect, the courts have no option but to take it for granted the legislature has said what is meant and meant what is had said. So a plain meaning is given into the consideration, and that is the reason the plaintiff is not going to get any compensation from the defendant for the charge. He made it to return the remaining corrugated sheets from the Singida to Dar es Salaam. So the language used in the act make it quite clear that the intention of the legislator was to place the common law right of the individual in the second place. So intention is the first, the legislator, and the second, the individual, what they thought it. I don't know whether did you follow my point or not, because you already read this case law in the legal methods. I need not to throw light that much. A plain meaning is taken and there is no ambiguity at all. So only the mistake is made. Instead of the 4,000, they made it 40,000. Who made it 40,000? Anyone can unmute and give me the answer.
Posto.
It is the error of the postal department. They did so. So now let us see the advantage of the plain meaning rule. Number one, constitutionally plain meaning rule respects the parliamentary supremacy and right of the parliament to make any law it may wish to, no matter how absurd they may seem. So the plain meaning means Parliament is given the supremacy over the word, they used it. The second point is the plain meaning rule encourages the precision in drafting and ensures that anyone who can read the legislative text can determine the law, and which promotes certainty and reduce that litigation. Now, disadvantage is if you take the plain meaning, sometimes absurd results will come out, and hence plain meaning is not that much perfect one. That is the view of the many people. For instance, you taken bitten by the teeth. The law prohibits either the cut or wound by an instrument. But the bitten by teeth, a teeth is not an instrument in their view. An instrument may be a sword, an axe, a crowbar, or any other external thing. But the teeth is not considered. It is an absurd. I told you that a karate man will kill with his only hands and legs because nodal points to kill a man. Can't he be held liable under the murder? Answer is yes. But if he could use the literary meaning, he did not use any instrument. He used only his body parts, like the incision made by the teeth. So hence disadvantage is there for the plain meaning rule. So the plain meaning rule fails to recognize the any language itself by the ambiguous, and the words may have different meaning in a different context. Can you give me one word which is having a different meaning in the different context? Anyone? Can anyone give me one word which is having a different meaning in the different context? Say Pasan. Say Pasan.
Person.
Pasan. If I use the word here, I am showing you. If I use the word plant, what is the word?
Plant.
Plant. Does it have the two meanings?
Yes, Professor.
Can you tell me what is the first meaning? What is the second meaning? Haraka.
One is,
Tree.
the first one is like tree, and second one is machine.
Not machine. A manufacturing unit.
Yes.
Can you give me one more example? Can you give me one more example? I already posted on the screen. Can you give me two meanings of the issue? Say Pasan. I will give the answer.
Pasa.
If you say the issues, in the legal meaning, issue means what is the question of law? Is it clear?
Yes.
Yes,
If you say
Professor.
the family meaning, family law meaning, they don't have the issues. Means they don't have the offspring. They are the barren woman. She is a issueless woman. Means she is a barren. What do you say? Barren woman in Kiswahili.
Mgumba.
Goomba. So if there is a two different meanings are there. Yes, mute. I'm getting the sound. At that time there would be ambiguity. If there is no such a two meanings would be come over there, at that instance, no ambiguity would be there. That is actually the thing. So now, yes. Now let us come to our point is, so the use of the plain meaning rule can be sometimes lead to the absurdity and loopholes which can exploited by an unmeritorious litigant. And number three, judges have tend to overemphasize the literal meaning of the statutory provisions without giving the due right to the meaning in a wider context, and placing emphasis on the literal meaning of the words assumes an unobtainable perfection in the draftsmanship. And hence, whenever a statute can be enacted, drafted, construed, it should be construed with a perfect and without any ambiguity words. Means strictly construed. Tax law and the penal laws are strictly construed. And the final point is finally, the plain meaning rule ignores the limitation of the language, including the development that may take place. A new development, a new things would come out. At that instance, plain meaning would not serve the purpose, and hence they are having the disadvantages. So that is about the plain meaning rule is concerned. Now let us go to the golden rule. The golden rule refers to the rule of statutory interpretation which requires the interpretation of the statutory provisions by looking at the ordinary and grammatical meaning of the word, except where doing so which lead to the absurdity. If you see the plain meaning would be there, it leads to the absurdity. Hence, a other meaning will be given by the judges. Yes, the other meaning is very much appropriate in this place, and hence we can say it is a golden rule. So, Glanville Williams says, the courts sometimes allow themselves to construe a statute in such a way as to produce a reasonable result, even though this involves the departing from the primary facie meaning of the words. The first meaning can be ignored and the second meaning can be used over there, because the second meaning is a right meaning. If they could use the first meaning, it leads to the absurd results. So the second meaning would be taken into consideration because that is more appropriate. This rule is used by the judges when the course of interpreting the statutory provisions they find out that the meaning is ambiguous, and to follow such a meaning will lead to the absurdity. And Michael Jander says the golden rule does at least have the saving grace that may be protect the court from the egregious foolishness. The term absurd simply means widely unreasonable, illogical, and inappropriate. And hence, the literary meaning will not be taken into consideration, but a different or the second meaning will be taken into consideration to resolve the issues are concerned. So the application of the golden rule in Tanzania in the case of Joseph Warioba versus Stephen Wasira and another, and you read this case law already. May I know what wording that you use there in the golden rule in this case law? If they could use the plain meaning rule, it leads to the absurdity. Hence, they use the second meaning of it, and that's why this case law has emerged. The first respondent, Mr. Stephen Masatu Wasira, was elected member of the parliament from the Bunda constituency. But subsequently, his election was nullified by the High Court, Luga Kingira, and who is a judge, upon an election petition filed by the appellant, Mr. Joseph Sinde Varioba. Do you know who is Joseph Sinde Varioba?
Yes, we know.
Yes.
Merely say yes is not the answer. My intention is to know the answer yes or no. Who is he?
Yes, we know he was a former prime minister.
Okay. So in the course of the dealing with that petition, the trial judge found that the respondent had committed an act of the corrupt practices, but declined to certify the same to the Director of Election in terms of the Section 114 of the Election Act. The appellant was aggrieved by such a omission, hence this appeal. If any person going to contest the election, he should have to give the clean chit of record that he is not a criminal nor he is convicted. So the main issue was whether the late trial judge erred in the law when having the correctly found the respondent to have the committed a corrupt practices. He declined to certify the director of the election that the respondent is guilty of the corrupt practices. The trial judge declined to certify that director of election because corrupt practice was not made the subject of certifying to the director under the Section 114 of the Election Act. And the Act provided for certifying the director of election the finding of the illegal practice only, not corrupt practices. How could you say only illegal practices only, not corrupt practices? Do you know the judgment which is given? Takrima also bribe. Is it clear?
Yes, Professor.
Yes.
Can you tell me what is the name of the case law where the Tanzania, I believe it is the Court of Appeal decision. Am I right?
Yes.
I have forgotten the name of the case law. Actually, I read the case law. Takrima means giving the presentation, a form of a gift, a zawadi. Even it includes a bribe. It is a disguised form of bribe. Am I right? Say yes.
Yes.
Yes, Professor.
See, when I was dealing the case law, where I was already told, you are not supposed to kill the bird, a small bird, Indege. Can you kill an animal? Can you kill a giraffe? Can you kill a tembo? Answer is no. Because law prevents there not to kill the bird. When the law prevents not to kill the bird, it doesn't mean that you have to kill the, sir, they said bird. Bird is a small animal, small one. But the tembo is a bigger one. Can you kill the bigger one? Okay, now Section 114, Class 1 of the Election Act stated, they said, where the court determines the person is guilty of any illegal practice, he shall certify the same to the director of the election. Counsel for the respondent had contended before the High Court that in the absence of any reference to the corrupt practice in the provision, there could be no basis of requiring the court to certify and finding the corrupt practices to the director of election. To counter the argument, counsel for the appellant submitted that the omission to require the finding of the corrupt practice to be certified to the director of election was simply through the inadvertence. When a person has made the corruption charges, when they have illegal charges, then corruption also comes under illegality, even though it is a corruption. Am I right? Here, the Court of Appeal was called upon to determine whether such an omission was deliberate or through the inadvertence. Having examined carefully the historical background of the amendment to the Election Act, the Court observed it would be therefore absurd for the Parliament to empower the Election Court to certify the sanctioned person found guilty of the illegal practice, but to let those found guilty of the corrupt practice go scot-free, especially considering the fierce war which the society has been waging against the corruption in recent year and continue to do so in the present day. And that means even you do a corrupt practices also, it's amount to illegal practices. Is it clear?
Yes, Professor.
I don't know whether you want to see. To kill a small bird, you'll use, what is that? I have forgotten the word. Catapult. What do you say in catapult in Kiswahili? Manati. You are not supposed to use the manati to kill a bird. Is it clear?
Yes, Professor.
Can you kill with a rifle? Can you kill with a rifle? Please say amna kimia. Sir, they said you should not use the manati, but I did not use the manati. I used the AK-47. I used the rifle. I used the 303 gun. I used the double barrel. I used the cannon. I used the revolver. Can you say so?
No.
Please give me the answer. Your kimia will kill me. Your silence will kill me. I want
The
the
answer
answer.
is no.
Yes. When you are not supposed to kill the manati, it doesn't mean that you can kill with the rifle. So the court give the interpretation like that. If you take the literary meaning of the manati, at that instant, it leads to absurd results. Even killing with a rifle, revolver, AK-47, cannon, or lower LMG, lower machine gun, high MG, higher machine gun, or anything, it is amount to the offense or it is amount to the crime. The court added that Section 114 literally construed would be discriminatory in this effect because, as already noted in powers, the court certified the sanctioned person found guilty of illegal practices while conferring no such power in the court in the respect of those found guilty of the corrupt practices, which is similar or even more serious offense. So, the contravention of the Article 13 and Class 2 of the Constitution of the United Republic of Tanzania, which in effect prohibits the enactment of any law which is either directly discriminatory or discriminatory in its effect, both the way. So, the beautiful example is Varioba case law in the Golden Rule. And if you happen to see the other cases, I am going to show you interpretation of the statutes. Importance of the interpretation. I don't know why it is not opening this file. Yeah. Importance of the legal theory. Oh, this is only one point. And there is the English case law also there. And I already posted you the handout, the English case laws. But I would like to deal at least one case law, statutory interpretation. Statutory interpretation, source of law, statutory interpretation. This is the same thing. Character is theoretical and aspect of the legal. Yeah, theories of the practical. Let me check this one. There is some problem of opening this one, but let me do it. But I already given the case law. The English cases are there where we can say the purpose of luring the customers for the sex, either you're standing on the balcony or you're standing on the street, doesn't make any difference. It's amount to the luring. Yes, you can see the other cases which I already given in the handout. Now let us come to the mischief rule is concerned. And the mischief rule of the statutory interpretation, which tries to interpret the statutory words by looking at the intention of the parliament through the history of the enactment of the particular act. And it is also called the Haddon's case. Haddon's case. That Haddon's case court ruled for the sure that the true interpretation of the statutes, 4 things must be considered. What are the 4 conditions would we consider for the Haddon case? Number 1, what was the common law before the statute was made? Before any statutes was made, what was the common law? First question. The second question, what were the mischief and defect for which the common law did not provide? A common law did not provide the mischief, and what is that? And number 3, what remedy has a parliament appointed to cure the disease of such a commonwealth? If any remedy is not given by the common law, at that instance, what the